you're meeting some great litigators in these monthly webinars, and Paul is really one that you want by your side if you're either in trouble or after the money. And I'm honored, Paul. Thank you very much for taking your time, and I'm going to extract a lot of good information from you. Now, the first slide, Tony. Okay, domestic asset protection trusts. How and why it all started. This is really important. It's important to know the history behind domestic asset protection, how it all started. It started because a lot of the trust companies in a lot of the states weren't making enough money. They saw that a lot, in fact, at one time, all of the asset protection work was going to offshore trust companies. And jealousy, envy, strife, the whole bit. So the jurisdictions, Delaware and Alaska, being the two big ones that started it out, it's now not quite 20 states, but I think we'll cross 20 states this year, where the states have enacted domestic asset protection trust laws. And it's important to ask, what are these laws? Well, they all have one thing in common. They're designed to make more money for the trusts in their country, in the state that they work in. They're designed to create more business for those trust companies. So every state puts a condition precedent to taking advantage of it, and so the lobbies for the trust companies and the banks in those states created domestic asset protection laws. It's not quite 20 states that have them, but a large number of states are enacting and have enacted domestic asset protection laws, and they all have one thing in common. These laws have the following provision in common. They force the person who wants to take advantage of the domestic asset protection law to hire and retain a trust company in that state. So the real benefit is it creates more money, more income for the banks and trust companies in those states. And we're going to be dealing with, great, now that you've gone to one of those trust companies, what did you really get? Did you get a pig in the poke, or did you get something that's going to really work? So how and why it all started? It started to make more money for the trust companies, and it started because all the business was going offshore. And the real stinker is the spendthrift clauses that everybody wants to put in trusts. I have never done a trust without one. I don't think any person in this entire country that's a trust professional would do a trust without putting one in, because it's a great clause. It's just black letter standard clause. Tony, go to the next slide, because I want to show people a broken down, smaller, typical spendthrift clause. I'm going to read part of this to you, and then I'm going to tell you a little bit about how it works. If you all could put these in your trusts, I would be out of business. I wouldn't have a job, because here's what most states do. The states eliminate the effectiveness of the spendthrift clause, and they say that people who set up their own trusts cannot take advantage of the spendthrift protection. And I'm going to read it to you. No discretionary beneficiary of this trust, including but not limited to the settlor, shall have the power to anticipate, transfer, sell, assign, or encumber any payment or distribution of either principal or income to be made under the provisions of this trust, and any anticipation, transfer, sale, assignment, encumbrance of any such discretionary beneficiary, whether a principal or income, whether by voluntary act or by operation of law, shall be void and of no effect whatsoever, and no distribution or payment shall be made by the trustee to any creditor, assignee, receiver, referee in bankruptcy, or trustee in bankruptcy of any such discretionary beneficiary. All that gobbledygook means that if you have a spendthrift clause in a non-self-settled trust, a spendthrift clause in a trust that somebody else set up for you, and you're the beneficiary, you can take advantage of this, and it's very powerful. Let me give you an example. My stepfather, about 20 years ago, was for a short time trustee for a bunch of rich brats in San Diego. And they had inherited a lot of millions of dollars, and they were just spoiled little drug-addicted jerks who became multi-millionaires. And the day that their dad died, they became ultra-rich, and they thought they could go start spending the money. One of them walked into the local San Diego Ferrari dealer and convinced the manager to put him behind the wheel of a $400,000 plus Ferrari, knowing that he was going to be inheriting tens and tens and tens of millions, and that he was going to pay for it in the next couple of weeks. So he got his red Ferrari. Well, my father, who was his trustee, stopped it. He unwound it. He would not allow the Ferrari dealer to get paid, because the trustee has the power to not pay money to any creditor of any discretionary beneficiary pursuant to this clause. It's a wonderful provision. It would put me out of business if this was effective, but it's not effective in many cases. Tony, go to the next slide. Here's the problem. This is from the Restatement of Trusts, and Restatement of Trusts is just a bunch of books that outline the common law, where the lawyers, law professors, and people do their best to state the law. This is the law. I'll read it to you. Where a person creates for his own benefit a trust with a provision restraining the voluntary or involuntary transfer of his interest, his transferee or creditors can reach his interest. That's Restatement 156.1. I'm going to read you 156.2, and then I'll put it in English. Where a person creates for his own benefit a discretionary trust, his transferee or creditors can reach the maximum amount which the trustee under the terms of the trust could pay him or apply for his benefit. This basically eviscerates the effectiveness of spendthrift provisions in what is called self-settled trusts. That means if you set up a trust for your own benefit, you don't get the spendthrift clause. So therefore, you're stuck. Your creditors can normally get to anything in the trust that you can get to. So if you set up a trust and you're a beneficiary, your creditors can almost always get to it under the laws of each state. Well, what did the drafters of these well thought out or ill thought out domestic asset protection laws do? They tried to eliminate these provisions. They tried to say that as long as you use a trust company in that particular state, you can have spendthrift protection with a self-settled trust. They sometimes put exceptions in it, but not normally. So the states, in order to make more money for their banks, wrote laws that were different than the common law, which is set forth in these two restatement provisions I showed you. Bottom line is, guys, the states have tried to undo a couple hundred years of laws by saying spendthrift provisions work when you pay our banks some money. Now, Tony, go to the next one. And guys, the reason I'm going so quickly is this isn't a giant issue, and we have lots and lots of questions, but I wanted to put it down and make sure that all of you who are listening have an understanding, because this is a huge problem. The people offering domestic asset protection do it very cheaply, and they do it with heavy marketing. They do it under the guise of state sponsorship, and you'll, by the end of this seminar, be asking yourself, do I really want this? Here's what the states did. The state solution to the problem was to validate spendthrift clauses and trusts which have assets within the states, thereby helping banks, and use a state licensed trust company. More revenue for the banks in the state. Now, Tony, go to the next one. Here's where the rubber meets the road. The people who drafted these provisions, and I'm about ready to ask Paul to chime in, but the people who drafted these these state asset protection laws didn't really deal with the effectiveness of their legislation. They dealt with the revenue issues to their banks. And the real problem is the full faith and credit clause of the United States Constitution. And just for kicks and giggles, I want to read it to you. Full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state. And the Congress may by general laws prescribe the manner in which such acts, records, and proceedings shall be proved and the effects thereof. Bottom line, the Constitution set up some general principles that every single state can enforce its judgments in every other state. In the world out there, there's no such thing as a full faith and credit clause between countries. A judgment from the United States or any segment of the United States, such as a state, is not automatically enforceable in the rest of the world. Unless there's a specific treaty, the rest of the world does not recognize and automatically enforce judgments from any other country. For instance, if you get a judgment in Switzerland and then you go to Singapore or you go to Thailand to try to enforce it, Thailand's going to laugh at you. Same thing in Switzerland. They're going to laugh at you when you take a Thai judgment. There is no international full faith and credit clause. The closest thing comes to it is there are so many mutual enforcement of arbitration award treaties, thanks to a man named Martin Domke, who was head of the American Arbitration Association and a good friend of mine at one time. Martin Domke, who founded the American Arbitration Association, pushed for treaties, and in the 50s he was able to get most of the civilized world to agree to enforce arbitration awards in other countries. But there's no such thing for litigation awards. So I always stay away from arbitration. There's a little, take that to the bank and pay for the seminar. That's really good information. Okay, Tony, next clause. And I'm going to, Paul, I think I've set it up pretty well. Guys, we have a country.
Good morning. Can everybody hear me okay?
I hear you fine, Paul.
Okay. You did set it up. First of all, I think there's a number of caveats that we need to make here with Rob's excellent introduction. One, I'm not going to opine at all on the history of why the states have done what they've done and you know, the issue on creating more work, et cetera, and the marketing and what have you. That to me, from what I want to address, is really kind of irrelevant. But I do think there are some very important facts, objective facts, that you need to look at. Okay. First of all, just by way of real quick background, I've defended foreign trusts in my life. That was what I used to do, and I've also busted them, foreign and domestic. And so, you know, I'm kind of a switch hitter when it comes to identifying and analyzing these situations. With that said, this is a very, very complex situation and set of circumstances on domestic trusts, foreign trusts, and what have you. And it's very fact-laden, meaning each case analysis needs to be done on a case-by-case basis. But I will tell you, very recently there have been two major decisions in two different court jurisdictions that would give anybody objectively, you know, cause to pause, if you will.
Oh, great, cause to pause.
If you want to try to, you know, get a slogan or a theme. And if I was to identify the theme of what I'm going to be talking about the next, you know, little while here, is just that. Is there cause to pause when you're doing this? And I think the objective data would lend one to say, yeah, I gotta examine what I'm doing or what I'm intending to do a little bit closer. And the reason being, and Rob touched on the full faith and credit, there's a a couple of other interesting facets, objective facets, I think, fit in the cause to pause analysis, if you will. First of all, there's a case out of the Western District of Washington, my home jurisdiction, and it's in re Donald Huber, H-U-B-E-R. What this case basically ruled was that an Alaskan Asset Protection Trust that was set up by the debtor, who initially filed a voluntary Chapter 11, and it was then converted by the creditors to a 7, basically ruled that the structure set up in Alaska, the Alaska Trust, was invalid, the trust was invalid, and the attempts to evade creditors, legitimate creditors, was also declared invalid. The facts of the case are somewhat complex, but I'll kind of give you a thumb sketch. Everyone on the phone, if you're from the United States, well, even if you're a foreigner, certainly is aware of the real estate debacle that started around 2007 and continued for a number of years. Mr. Huber was a developer in the Pacific Northwest. Mr. Huber, along with other parties, had personal guarantees on many developments and was going underwater. Mr. Huber also had real estate assets that were producing positive income. At the time when he knew it was imminent that there was going to be litigation, foreclosures, etc., he rushed to set up an asset protection trust in the state of Alaska, whereby, coincidentally, Mr. Huber transferred into that trust the various different LLCs to end up in that trust, all the income-producing real estate, none of the bad debt real estate, and a number of other assets, and tried to claim that he could rely upon the asset protection trust structure in Alaska and take advantage of those rules. Well, they jumped forward to the litigation. What the court basically looked at was, one, on a choice of law. Was it Alaska or was it Washington? Because we did have a spendthrift trust, and Washington law does not recognize spendthrift trusts. And the court analysis was, and I'm paraphrasing grotesquely in some respects, but like I said, if you want to look at the case law, the actual case, I don't know if they know how to get a hold of me, but they can get a hold of Rob, and I'll be happy to forward people copies of the recorded opinion.
Paul, you're on the faculty at Asset Protection Training. All your contact information is there. And by the way, you said Washington does not recognize spendthrift trusts. What they don't recognize is self-settled spendthrift trusts.
Excuse me, that's right. And thank you for the clarification. But the court identified, and they looked at the contacts between Alaska and Washington and whether or not Mr. Huber had sufficient contacts to establish some kind of nexus with the state of Alaska to justify what he had done. And the only connection he had in Alaska was a $10,000 certificate of deposit that he opened up with the trust company in Alaska. All the real estate, all the income-producing properties, all the obligations, all the assets, everything else was located in the state of Washington. Thereby, the court ruled Washington law will apply. And because Washington law applied, the trust was void on its face. Of course, that created problems for Mr. Huber. Then they went in and did an analysis on whether or not, we're talking about whether there's a fraudulent conveyance, and of course they went through that analysis. And, there were things threatened, pending, expected. He transferred assets that out of the reach of creditors, knowing that the creditors were after him. He did so for the intent of cause a hindrance to those creditors and a number of other factors. The bottom line is the trust was held invalid, and it's law in this area. The second case is one that just came out, and Huber was back, let me see what the date of the order, May 17, 2013 was Huber. The other case that recently was decided out of Florida, in this case is, give me a second here to find my notes. Oh, Berlinger v. Castleberry. And Berlinger v. Castleberry was decided in Florida November 27, 2013. And then Florida would like to think, in some respects, I would concur, is pretty progressive when we're talking about asset protection trusts, and what have you. But the court there ruled that not only could creditors attack a spendthrift trust, but they can also attack discretionary trusts. And the trust bar in Florida is up in arms about that, because this is putting at risk, quite frankly, the structures that they're talking about with asset protection domestically. Because like they've appeared to have done a pretty good job of setting these things up. And the problem basically arises on what's called an exception creditor. In the case of spousal support, child support, IRS obligations, super creditors, U.S. government, Florida government. I'm paraphrasing again grotesquely here, but nonetheless, the court essentially said, for reasons I won't bore everybody on this phone call with, that they had the right and the ability, those creditors, to break through the trust and basically seize those types of assets. So objectively speaking, we've got two states that have two court opinions that have looked at domestic asset protections and opine basically, those protections that the parties thought they had don't exist. But keep in mind what I said on the cause for pause. It's fact-laden. It's fact-heavy. If you look at the Huber situation, those facts are pretty abysmal for the debtor doing what the debtor did. I don't know if people on the phone are facing similar situations, but it led to, from my subjective thinking, the court wanted to find a way to nail the guy, okay, to be able to not have him take advantage of these barriers. And keep in mind, and Rob, again now, from a more general overview, generally speaking, with domestic trusts, he is correct. You do have full faith and credit. Enforcement of them domestically is recognized. You have a situation where you can attack the validity of the trust much easier in the United States than you can in a foreign jurisdiction. You also have the fraudulent conveyance situations that exist. So there is risk. Now, is there more risk in going offshore? Objectively speaking, I think we're looking at a better ability of a creditor to attack a domestic asset protection structure. Further, and Rob is correct, we no matter how you slice it, okay, in Delaware, which is not a bad state per se, but Delaware's got a 4-year fraudulent conveyance statute, okay, where you can look back up to 4 years. There are other considerations to be made too. You can get jurisdiction over domestic trusts. You can, attach. You can attempt to get asset freeze orders much easier. Now you have to post a bond, of course, but they're still much easier domestically than it can be done offshore. And I think another consideration on the cause for pause is in the United States, a lot of lawyers that do the collection work either do it, on a straight contingency or what we call a blended fee. And just so there's no misunderstanding with terms of legal significance, contingency fee is we're prohibited ethically from buying lawsuits, so the client has to pay the costs. A lawyer can't say, I'll pay all costs, and they could forward those costs, but the fees from the lawyer, are based upon recovery. And typically those contingency fees, range between a low of 20% up to 45, 50%, depending upon the circumstances. Internationally, those type of arrangements don't exist. And you have a blended fee where you have less percentage of the recovery at a less hourly rate. So you have more of the attraction, if you will, of savvy attorneys, creditors, attorneys, being able to utilize the laws to be able to go after debtors in those situations. Further, you've got, besides the full faith and credit, again, you've got the ability to look at the validity of the trust, and once it's unwound, if it's domesticated, those assets, what's the result? Of course, that's a rhetorical question because there's 82 people on the phone, and you can't answer that question, so I'll answer it. The result is the ability to now collect. And keep in mind something else. Savvy counsel should, from the outset, and I use this quote in other presentations, ask this very, very important question, okay? And it's, from that movie Jerry Maguire, where Cuba Gooding asked Tom Cruise, not the question, made the phrase, "Show me the money." And if you're looking at a domestic situation, the answer to "show me the money," from my perspective, is a lot easier than if I got to look offshore in the legitimate impediments, barriers, roadblocks, hurdles, or however you want to classify it, in going offshore. And there's a number of favorable laws in foreign jurisdictions, the primary one, of course, being the fraudulent conveyance statute time frame. Many of those foreign jurisdictions have a zero time frame for foreign trust. Plus, there is a bit of I don't want to say novelty, but there's a uniqueness when we're talking about offshore that I think, from a domestic lawyer's perspective, is confusing. And quite frankly, they recognize that there's an impediment, there's that barrier there. And what typically happens in these types of cases is another phrase I've used all the time: client fatigue. Creditor plaintiff gets tired of writing checks, whether it's checks just for costs and expenses, or if it's on the hourly basis. It gets to be a burden because of the investigation and the tracing that needs to go on. Now, we're assuming here a couple of things, and then this is from the analysis. We're assuming we're talking about individuals who are not Huber-esque, if you will. We're assuming that the trusts were set up, they were old and cold, nothing threatened, impending, or expected. And if you look at it from that analysis, in other words, you should be somewhat secure. Where are you more secure? Again, aside from the subjective presentation of why these domestic trust things have been set up as far as trying to create a marketplace, but are you more secure? And I think that comes down to an analysis now of who are you trusting to set up your plan? Who are you trusting as far as is going to draft the instruments that are to protect you? And are you asking the right questions with those parties that are doing that? And kind of contrary to the topic, if you will, one thing I will add that you should always, always ask, whether it's domestic or foreign, is who's controlling the assets. And if you as an individual have $10 million to keep the numbers, simple to visualize, if you will, and you're being asked to give up all control of your assets, whether it be domestic or foreign, you need to hit that pause button. There's cause for pause there, okay? You need to ask yourself, what's the structure, what's going on, because there's a lot of bad players, too, in the foreign arena that are promising things that just, quite frankly, are not true, and then you end up with the Madoff situation or the other ones that are in the news, but happen at a smaller scale. And the analogy being, if it's too good to be true, it is. If they're promising too big of a return, it's not sustainable. If they're promising 100% absolute, without a doubt, protection, that's not true. Now, to set them up legitimately for estate planning, for wealth succession purposes, and just good business sense, the question then, after you hit the pause button, is it domestic or is it foreign that offers you the better protection? And if we're going to kind of digress or divide a little bit here, I guess, the question then on domestic versus foreign is, if you want to go foreign, who are you using, who are the parties that you're using, what the trust company is, what's the banking institution, what's the jurisdiction, what's the laws that are in effect there. And you need to ask and get answers to all those questions. But from my experience, when those questions are answered and we're talking about verifiable parties that are setting up these structures, you do have, well, I say better protection. I think if all things being equal and you want to diversify your portfolio, going offshore is a better route. Assuming, again, you're not a bad guy or bad gal that's trying to avoid the creditors. I mean, if you are a bad individual, and you have a motivated party, I mean, you're going to run into some problems, and you may even run into problems domestically, and to get the ire raised of the court. They may not be very educated. In many instances, they're not. And they're going to say, Mr. or Ms. Smith, return these assets if they're offshore. Ms. Smith says, I can't. I don't own or control them. Judge says, I know you tell me that. Wink, wink. Okay. But I'm going to hold you in contempt until you return them. I mean, those are horrific war stories, not the norm, but they have happened. Okay, and you need to look at that. Let me further tell you the difference too, as well, internationally versus domestic, is the burden of proof, if you will, and this is a big one. Objectively speaking, from the burden of proof to unravel invalidated trust domestically versus the burden of proof necessary to unravel and invalidate a foreign trust. Domestically, the burden is, preponderance of the evidence. That's a 50.1 type of a deal. Internationally, in the jurisdictions that I've worked in, it's a beyond the reasonable doubt burden. As well as internationally, if you want to attack that, you have to relitigate it there. You have to have local counsel. Many times you have to post a bond for defense counsel's expenses, and it won't be a contingency fee type case. It's another reason to hit the pause button and say, what are we talking about?
Well, let me ask you a question about client fatigue.
Say what now?
Let me ask you a question about client fatigue, because I know that's a big factor, and you've focused a lot more attention the last 4 or 5 years on actually breaking other people's trusts rather than defending trusts. But I can let me put on that real quick for the listeners. The Huber case, our firm was involved in busting that trust. So okay, well I did not know that, but I'm going to ask you an unfair question then. I was going to say take the Huber case with its focus on Delaware, on Washington State and Alaska, and then change the facts, take the same case and put a Belize or Cook Islands trust company with good counsel and good representation on the other side. What would be the difference in the retainer or the total estimated potential cost? Is it roughly the same, or is it multitudes more with the foreign?
It's more expensive foreign without a question, based upon my personal experience. I mean, if you ask 10 lawyers, you might get 10 different answers, but that's my experience.
More like a little bit more, or more like?
No, significantly more.
Yeah, double, triple, quadruple more, guys.
Well, I mean, significance is beauty in the eyes of the beholder. Some people listening, if I said $10,000, that might be significance to them. If I say $100,000, I think we're talking about a threshold. I would say, it also depends upon the amount and the facts and what have you. But assuming the fact pattern is the same, assuming the amount of money is the same, assuming the structures are as you identified, and assuming we've got a basis to bust a trust domestically versus busting the trust foreign, it'll be more expensive. Foreign, more intensive in costs as well for investigators, local counsel. And by the way, local counsel in many different jurisdictions are extremely expensive compared to American rates, even New York.
I mean, $1,800 an hour, guys.
That's right.
Unbelievable.
Yep. Yep. I don't know what the pound translates into So you're talking about $800 to $1,000 pounds an hour in some of the Commonwealth jurisdictions. Now, we get, our firm, because we work a lot internationally, I mean, we get some, I will say, favorable rates, but what's favorable? Again, okay, it's not $1,500, it's $950. Okay, that's still a lot of dough. Plus, you have the burden of proof issue when you're talking about what's more favorable versus not.
Well, that was another question, preponderance versus, can you
beyond a reasonable doubt.
Explain the difference a little bit more for those of us who don't have that law school tattooed in our back of our brains?
Okay, in our country, preponderance of the evidence is a civil standard, generally speaking. There are other, I mean, with fraud, for example, they may hire, depending upon the statutes in the different jurisdictions, it may have a clear, cognate, and convincing standard, which is higher than preponderance, but it's still lower than beyond a reasonable doubt. It's kind of what kind of weight do you put on that? And I think everyone on the phone would recognize, domestically, if we're talking about someone being charged with a crime, for example, that's a beyond the reasonable doubt threshold, much, much higher. And a case in point, I think, is it's illustrative, and I offer no position or opinion about what I'm just about to say. Again, objectively speaking, those of you on the phone, there seems to be 80 still on the phone here besides us on this call. Some of us are old enough to remember, the O.J. Simpson trial. Okay, there was a criminal trial, right? If the glove doesn't fit, you must acquit, and that burden in the criminal trial was what? Beyond a reasonable doubt. Everyone also recalls what happened after the criminal trial ended. Mr. Simpson was sued for wrongful death civilly, and basically he wasn't convicted, he was found liable, right? Well, the burden of proof in the civil action was preponderance of the evidence. Therein lies a real-world objective difference. Similar type evidentiary presentation. I didn't follow the trials closely, but enough to know similar type facts and evidence. In the criminal setting, beyond a reasonable doubt, he was acquitted. Some people would say, well, that was because of the jury bias, et cetera, et cetera. Again, I'm not going to opine on that. It is what it is. And yet, a different jury found Mr. Simpson liable by a preponderance of the evidence in the civil setting. Let me also say something, too. I am not, and I want to be real clear here, saying the courts were necessarily correct, both in the Berlinger matter in Florida or the Huber matter in Washington. However, what I am saying is that's what the courts ruled, objectively. And understandably, the Florida, Trust and Estates group, bar, asset protection people, are not happy with what happened in Florida. I cannot blame them. I have not dissected that case in great detail, but what I will tell you, objectively again, is I would much rather not have law, even if it's bad law, that has to be overturned or some statutory revisions be done. Okay? Same thing with Huber. I would rather not have that if I was thinking about domestic asset protection, those types of cases floating around. Again, that's, cause for pause. And I think, the analysis needs to be, for you listeners, I certainly am not advocating one side or the other. I think you're listening because you want to get some, data, some information. I also would say, I know that you could get other counsel on the phone talking to you, and they will probably sing a different tune. That's why I'm trying to be objective and not subjective in what I'm talking about. And again, the advice I give is, okay, what does all this mean? How does that play out in my scenario? And let me give you a case study as an example so you can kind of visualize, if you will. I'm a visual individual. What I'm talking about in cause for pause, okay? Hypothetically speaking, let's say you have a business and it's, in our area, let's say it's a software business, okay? And it's doing fabulous, and you have a company, I don't know, Microsoft or Amazon, something like that we have here in Seattle, and they want to acquire your business, and it's an asset purchase, and you're going to net 10 million bucks on the deal. All right? You've worked your tail off all your life. You know, you've foregone, you know, your kids' first steps, and you've done the things that, you know, capitalists like, but you've suffered family-wise, you know, and now you're ready to, your spouse, whether it's your wife or your husband, you know, okay, we've got this nest egg now. We can hit literally, you know, let's rest easy now and enjoy the fruits of our labor. So you got 10 million bucks, okay? In that asset purchase and sale agreement, there were many, many, many warranties and representations. And any business people I have on the phone right now know exactly what I'm talking about, okay? And the lawyers, the transactional guys, back and forth on what was going to be done. The due diligence was done. They looked at P&L statements. They looked at, you know, your stock structures and seeing if there's any lingering, you know, liabilities out there, blah, 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 blah. And it's been an exhausting process, but finally it's done. The wires hit your account, you know, at anywhere, because I don't want to advocate a bank, you know, anywhere domestic bank. You got the money. Okay. We live in the most litigious society in the world. In some respects, I'm an advocate of that. I mean, the proper quote from Shakespeare, I think it's from King Lear, isn't kill all the lawyers. It is basically for the demise of society, the first thing you do is kill all the lawyers. So I am a supporter, as I call us, the brethren of the cloth, because we do good things. We also do bad things, but we do some good things. Needless to say, though, we're very litigious, okay? So there's a risk now with that 10 million bucks sitting there on whether or not you can keep that $10 million. And you may say, well, what are you talking about, Paul? How can that be the case? Well, I've handled those types of litigation as well. Let's say something came up and one of your patents, you know, is challenged, and now you're talking about an invalidity occurring on some of the IP that you sold to one of these companies. Okay? Bet your bottom dollar, all right, you're gonna have a problem with that. All right? And this doesn't happen, let's say, for a number of years. So at the time you got the 10 million in our case study, there's nothing threatened, nothing pending, nothing expected. Everything's been legitimate, everything's been above board, everything has been great. All right? But the acquiring company can be litigious, let's say. I'm not saying one of the two examples I gave are litigious, but they can be. They want a better deal. Part of their business plan is litigation, all right? And you could get sued for anything, right? I mean, as long as there's some basis behind it, which isn't a very high threshold, you can get sued and drag your butt in court and have to defend on something like that. And it's expensive. Litigation, even domestically, is ridiculously expensive. A lawyer says, let's go to court, either has never tried enough cases or is a liar. It just, you want to avoid it, okay? So what do? There's that pause for cause. Well, how do you protect yourself? What kind of estate planning do you have? You know, where are you going to diversify the funds? What are you going to do with the money? And in today's global economy, and I think the stigma of, you know, drug money or illegal money, laundered money going offshore, I think it's lessening all the time. On that pause for cause, and what we're talking about here, and whether you go domestic or foreign, you need to ask those questions of, all right, what can I do to protect myself and my family? And I'm not talking about a situation where you're looking at divorce or anything like that. What can I do? And should I do something? And the overriding, again, trying to be objective here, answer to that query is you should do something in your estate plan. And one of the questions when you go to your estate planning attorney, and you'll attract a good lawyer with a $10 million nest egg and vet those counsel out very, very carefully, is, do I do an asset protection trust? If I do I go foreign? Do I do domestic? Do I do a combination of those? Okay? And one thing you want to examine on that is the security of those funds. And again, I'm not talking about investing some, business plan, some funky thing offshore where you're promised ridiculous returns and absolute safety, and nobody could ever touch it ever again. type of situation. There, you don't pause for cause there. You run and flee as fast as you can from that. I'm talking about, you've got this. You want to build the wealth. You want to provide for your kids' college. Let's say you have an older mother like I do. You want to take care of her in her lasting couple years that she's got, blessed with being on earth here. Good things. These are good people. So what do? How do you protect yourself? So 5 years down the line, if you have that IP situation where they say that patent you repped and warranted in that agreement because the statute limitations hasn't lapsed yet, okay, it was invalid. We want our money back, or we want 10% of it back, or we want 100%.
Paul,
so,
what's the lawyer going to say? We got 12 more minutes, and I want to finish this. We got 12 minutes, and tell me, the guy walked in, your firm is the firm in Seattle that's most likely to get this client. And he says, I want to do an asset protection plan. And he says, tell me whether to do domestic or foreign. What is the answer?
For $10 million, I'd probably do a bit of a hybrid, but depending upon the particular facts, and but also depending upon what that purchase and sale agreement has with the reps and warranties and things like that, definitely there would be a foreign element to it, maybe a more major foreign element to it, because I would feel much more secure with old and cold, established asset protection trust, IBC, International Business Corporation, LLC type, hybrid type of thing on a foreign soil than the domestic.
And if you came into your office, I'm gonna move it along because I want to extract all the information in your brain, but we do want to finish at the top of the hour.
Yes,
If he walks into your office and says, okay, 5 years ago I did this Alaska trust and I want to put my $10 million into it, and I made all these representations and warranties in Seattle, are you going to say, fine, let's move, or let's take that trust and take it out of Alaska and into another country? Or are you going to be sanguine with an old and cold domestic plan?
I don't feel so secure. I mean, the Huber matter, of course, has bad facts, but you still have the problem with the lesser degree of burden of proof. You still have the problem with the full faith and credit. I mean, you've got issues that you can avoid better offshore, and we're not talking about tax evasion issues. This is all clean money, net income money. The foreign structure just makes more sense.
Paul, what I do when I have clients in that situation, and heck, this morning I just got one. A guy's wife says, I'm going to divorce you. He's got a lot of money, and some promoter in Nevada is saying, come in, do a Nevada trust. I'll charge you $2,500 the first year, $200 for each year thereafter. And he says, that's so cheap. I'm just going to put it in there, and he guarantees me it's going to work. I tell my potential clients or people who call in, when you get a local estate planner or some promoter that says put your money in this domestic asset protection structure, I say always ask if they have insurance, and even more important, ask them to put the safety that they're promising you in writing, because all of them, without exception, have to gloss over the fact that we have a full faith and credit clause. I've never had anybody who's a legitimate practitioner be willing to say that domestic asset protection trusts are safe when they've been asked to say so. Plenty of articles, but when the lawyers are asked to put it on their letterhead, it doesn't seem to happen. Any comments on that?
Again, I think that there may be a place for that, but from my world and what I'm being retained to do, which is this client is seeing me, so I don't do what I do also, go against him or her, okay? The best way to prohibit, besides conflicting me out by hiring me, I guess, is to set up a foreign structure. It's just easier domestic. That doesn't mean domestic, I don't want to confuse the issue here, Rob. Does that mean domestic's bad? That's why you hit the pause, the cause for pause, okay? Look at that, and where's your comfort level? If you want to be more secure and you vet out appropriately with the professionals you have at your disposal for talking about this kind of money. I mean, you get what you pay for. $2,500, you get what you pay for. I mean, this person, it's not a form figure. It's got a, one size. That's another comment. I think we forgot this on the cost for pause. One size does not fit all.
I agree. Now, here's what I want to do. We have 8 minutes left, and we've been going for 2 hours, guys. Those of you who've been attending these webinars, we can ask questions. Okay, questions, Tony.
Okay, so what I'm going to do now is I'm going to put a poll up on the screen, and just as we're answering questions, for those of you who can see this, just give us your feedback on this question here about how many of our attendees have a domestic asset protection trust. One of the questions that came in, Rob, was it dealt with how is estate planning or inheritance handled? Are probate and gift taxes avoided with asset protection trusts? For example, can a DAPT or an FAPT function similar to what people usually hear as living trusts? Or is an FAPT superior to a DAPT?
Okay, let me answer that. Paul is a great litigator, and he's surrounded by estate planners and trust people, but this is sort of my bailiwick. They both work the same. Domestic and foreign trusts that are done for asset protection need to be integrated with your estate plan. The proper way to do it is to use a fancy power of appointment provision so that you can control your domestic or your foreign asset protection plan by changing your will or your estate planning trust. Most people don't do it that way. I think they do it so that you have to amend the domestic trust or amend the foreign asset protection trust because it costs more money. And I think the smart way is to keep it so you never have to amend it and you control it by power of appointment provisions. And it makes no difference whether it's foreign or domestic. It's the same process. And I am going to do a seminar on coordinating your asset protection planning with your estate planning.
And along the same lines, is it more expensive for a creditor to litigate against you with a foreign asset protection trust and more expensive to defend the foreign asset protection trust?
Paul already answered that with a resounding yes. I would guess it's at least 5 times more expensive, but I'd love, Paul, dare you say a number?
Oh, I think it's impossible to approximate. I think it's more expensive just because of you're in a foreign jurisdiction, and you have to play by their rules, and it can be very difficult depending upon that jurisdiction. They're more expensive to defend foreignly. Well, it depends upon how skilled and how motivated the plaintiff is. The party, the creditor is. It can be.
All right, we have an attendee who asked about their parents. They're in their 80s. They know nothing of asset protection, but the child wants to know how to help the parents protect their assets for the siblings. They own a house free and clear. It's worth about $200,000. They have just about $300,000 in assets. They have no long-term care insurance, and they're afraid an assisted living facility is going to claim access to their assets. Parents are veterans, receive VA medical services, and want to know what is the best way for them to go about protecting this for their parents.
Again, get with a local estate planner. You have to do that. That's the place to start. And with asset protection, you can go to somebody like me. You can go to Paul, a firm like Paul's for your estate planning. Get somebody good who knows you. Get somebody younger than your parents, ideally younger than you. You want them to be there for you when your parents are dead and be there for you like a doctor who is a general practitioner. Not a surgeon, not a brain surgeon, not a heart surgeon, somebody that looks over your whole situation and can be with you for the next 20 years. That's what an estate planner really is. It's like a family doctor. Get somebody who loves you and cares for you if it's possible to find. Paul, any suggestions on top of that?
No, I think that is what you need to do.
Another listener asks, suggest that moving assets offshore is extremely risky since we don't know the laws or safeguards in other countries. There are risks associated with trusting anyone, and more so with people outside the U.S. where regulations are lacking. Rob, what would you say about that being a valid or invalid?
That's absolutely invalid. You should never trust anybody inside or outside the United States with your money. I would take the mid-level banks in any part of Europe and compare them to the best, most powerful banks in the United States, and you'd find that those mid-level banks are much more conservative and have much more substantial capacity to withstand economic downturns. Our banking system is very weak in the United States, has less than 1% reserve requirements, meaning basically all the cash that the bank has is in the bank offices and in the teller machines outside the banks. They don't have reserve requirements. Our system is very weak, guys, in America. We have $100,000 of insurance, that's it, or $150,000. I can't even remember how much.
Rob, earlier on the webinar, Belize was one of the locations that you mentioned as a good location for an offshore trust, and one of our listeners has said that they've heard people suggest that's not the most stable location. How would you respond to that?
I don't think that any of the offshore asset protection locations are stable. I would not put everything I own into any bank in any of those little countries. We're talking the Cooks, we're talking Belize. Those are the two main offshore asset protection jurisdictions with good laws. Yeah, $1 million, $2 million, that's all right. If you're going to put the whole farm in, spread it around. Put some money in Switzerland, put some money in Singapore. Don't forget ABA AMRO Bank in Holland, and go to 4 or 5 different jurisdictions and 4 or 5 different institutions. We're going into a period of high instability, but I do like Belize because they have 24% reserve requirements in their banks, and I have most of what I have protected in Belize, but I'm not somebody with $20 million that I can logistically spread it around like that. When I have a little bit more, I'll have money. I have money in Holland, for instance, and Switzerland right now, but not large money, and I'm willing to make those larger. I love Belize for their laws, and I love them for their stability.
So 90% of our listeners who voted today do not have a domestic asset protection trust in place. Someone asked that they have an existing Nevada Family Limited Partnership holding all liquid assets and wants to know how they can reinforce that asset protection by combining it with an asset protection trust.
Well, anybody with a domestic asset protection trust should strongly consider moving it offshore. Not starting fresh, but moving it offshore. Someone with the LLC hasn't done the job yet because that person is still the owner of the LLC's membership interest. As Paul will explain probably as soon as I shut up, as soon as they win a lawsuit, they can usually they can often grab onto that membership interest. And when they do grab onto that membership interest, then in some jurisdictions, and in fact many jurisdictions, they can control the assets held by the LLC. An LLC alone doesn't take it off your balance sheet. That's the problem. So put a foreign trust in place, and that's a good start. But you can only tell by when you look at all the facts. Paul? Paul?
What now?
Okay. I just wanted to know if you had anything more to say to that. I'm trying to be really fast, so I'm probably missing things.
I lost you, Rob.
Okay, I think I did it right. Go on to the next question.
Someone wants to know they had some offshore trust investments caught up in the Madoff scam and want to know how can that be avoided in the future.
Don't give your money up to somebody to have absolute control of it.
Trust nobody, period. Paul's absolutely right. Don't ever give control of your money away to anybody but yourself until you're too sick and ill to watch over it yourself.
If it's too good to be true, it is.
Yep, and pigs do get eaten. All of these stupid sayings really are true.
I mean, part of the Madoff problem, I think, Tony, was greed. Greed from the victims, too.
So since we're talking about foreign and domestic trust, one question that came in was, is it okay or even necessary to have more than one trust? And if so, can one, if that's redundant, can one be folded into another?
Well, the answer is yes. It's sometimes more work to do that. And like Paul said, with the guy with 10 million but had a lot of domestic investments, he might do a combination of domestic and foreign. I would never do domestic because there's never been one ever challenge that held up. Not one has ever held up. I would never do it. I think it's almost malpractice to do it. And if the lawyer won't tell you it's safe, don't do it. That's my feeling about them. But I'm really on the lunatic extreme. I don't think you should take risks that you don't have to, just like I don't think you should trust anybody if you don't have to.
So we put up another poll. Continue to, if you would participate by answering those questions while we're going on, we'd all appreciate your feedback. One attendee owns an LLC and wants to know how the trust can help with more protection. Will the trust have to file a separate income tax from the LLC?
It depends on the type of trust you have. Normally, the trust, if it's an offshore trust, will have to file an informational return, but it will not be a tax-paying type entity. It usually is a grantor trust. Grantor trust meaning it's a pass-through entity, it's for tax purposes, and it will use your social. It's a grantor trust because normally the settlor, the person who made the trust, will retain the power to change beneficiaries. That makes the trust almost invisible for tax purposes. So you can hook up a trust to it. It's a complicated situation. It can work the other way if you don't do it correctly. So get good advice, whatever you do. Always, always, always involve your CPA and your local lawyer in any asset protection planning you do, period. Always do that.
A couple people have asked about South Dakota Dynasty Trust. Is that worth considering for funds kept domestically? And what are the problems that are not obvious?
No. The answer is no, and let's go on. That's not worth a long discussion. The answer is ignore them, avoid them.
Can domiciled assets in a domestic trust that are in the same state as the trustee, this question's not clear, I apologize.
Hey, gentlemen, I got a lead here. I hear you.
Thank you, Paul,
very
much.
Is that okay?
Yes, thank you very much.
Okay, everybody stayed on the phone. Thank you so much. I hope we were clear with what we were talking about. If there are any questions, as Rob said, you have contact information. If I can answer them, I will. If I can't, I'll reply saying I can't. How's that for being direct?
That's direct.
Thank you, Paul.
Thank you, Tony. Thank you, Rob, and thank you to everybody else. I must leave. I apologize.
Thank you, Paul.
Bye-bye.
Right. We are over time now, Rob. I have maybe one more question we could go. We have an individual is packaging a company for sale and is hoping to sell it this year and create a new foreign asset, is creating a new foreign asset protection trust. Let me say that again. They're packaging their company for sale. If they sell it this year and create a new foreign asset protection trust, is the protection limited because the asset protection trust would be new?
The old and cold matters a lot, and the facts matter a lot. This is what I almost always do when somebody is selling a business, is I actually have the business sold by an entity owned by the Asset Protection Trust. Usually because of the representation and warranties, you have to negotiate that because they'll want them to be personal, and they oftentimes have to be personal. But it's almost always better to have the actual stock sale, if it's a stock sale, be handled from an LLC owned by a Asset Protection Trust. That way the money flows directly into the protected environment and never enters even into your personal financial bank accounts and your personal financial statement on the way. So the second you close, the money's off your balance sheet in a protected environment, because fully a third of sales in the litigation within 3 years because of the representations and warranties that Paul mentioned about 40 minutes ago.
And in regards to that, someone has asked, does a foreign trust take assets off your personal balance sheet?
A properly done domestic or foreign trust does that.
And someone recently formed a Nevis LLC, but they don't have a bank account yet, and they're looking for the best way to integrate that with their activities in the United States. What would you suggest?
Well, it's very difficult to do that. First of all, Abby, are you there? I hear you speaking. Abby, are you there? I want you to
unmuted.
If you are.
Yes. Okay, go ahead, Rob.
Okay, you didn't hear it. The answer is that the Nevis LLC that opens up a bank account will have difficulty doing business in the United States out of a bank account. It's difficult to write a check. It's difficult to pay a bill, and usually it's just hard to pay bills in the United States from a Nevis LLC. It's a great, even if the bank account abroad. The Nevis LLC, first of all, needs to be owned by an asset protection trust to take it off your balance sheet. Secondly, you need a good account in Nevis or Belize or Switzerland, or I hear somebody breathing, so whoever's breathing, stop or mute yourself. But we have very, very sincere hurdles to overcome to actually do business through a Nevis LLC. You can hold money there. You can have millions and millions of dollars there. But if you're going to have people on salary in Clinton, New Jersey, you're going to need a bank account in Clinton, New Jersey to pay them their paychecks, not some Nevis LLC. It's just the practical side of it is very difficult.
One of the other questions was, and it ties right into that, is how difficult is it to take funds out from a bank account that you have in Belize to pay bills? And they're wondering if expatriation is something that they have to do in order to utilize funds in a foreign bank account, particularly established in Belize.
Well, Belize is no different or no worse or better than any other country. That's a small country. They're all difficult, but the answer is it's really easy to take money out of your foreign bank account and bring it into the United States. What's getting hard is taking money out of the United States and sending it abroad. Wells Fargo Bank is making it really difficult on my clients. Those of you who have Wells Fargo as your primary bank, go and try to wire some money to somebody in Switzerland or Belize or Cook Islands or France, and you're going to find it. They make you jump through a lot of hoops unless you're part of their private banking. And the other banks are going that way because there's a sincere effort in the United States government to stop the outflow of capital. It's becoming, exchange controls are becoming more and more a possibility in the United States. Places like Belize don't have it. Venezuela is instituting exchange controls so you can't remove money from Venezuela. Expect that to happen in the United States. I don't expect it to happen in places like Belize, and if it did, I wouldn't have money there. You need money in a place where you can move it on a spur of the moment, a day's notice, and put it wherever you want to.
All right, we are far over time. Rob, do you want to take a couple more questions, or would you like to end?
Why don't we do 2 more questions and call it good? And next month or maybe we'll do a seminar with just questions, depending on how many are unanswered. But I think we promised an hour. Let's stick with pretty close to an hour.
We literally have dozens and dozens of questions. It would take us another 2 hours to get through them all. Someone mentioned that there was a convention on mutual administrative assistance in tax matters signed by Belize, and wants to know if you're still comfortable using Belize where there's a risk of a tax problem.
Oh, well, you don't want to take on Uncle Sam. Asset protection is not going to protect you from your tax obligations. Uncle Sam is a formidable opponent. They know everything you do. They know where you are. They know what you think. They know who you call. They know what you're looking at on your computer right now. They know you're at this seminar if they want to find out about you. They actually know everything about you. And yes, they can find you. The question is, do they? And the answer is yes, if they really get serious about it. The problem is there is no country in the world that will automatically or even when requested enforce U.S. tax laws. As long as you don't commit a crime, Belize will not enforce U.S. tax laws. Why? Because the United States government refuses to enforce Belize tax law. And because under the doctrine of comity, Belize and the United States refuse to enforce each other's tax laws. That doesn't mean they don't enforce each other's criminal laws. They will let marshals into Belize to arrest people, just like they will let marshals into Switzerland to arrest people. Most civilized countries do that. And Belize is sort of coming into the world of, it's going from a third world to a second world country, where it is either going to have to basically have a crappy and dishonored banking system, or they're going to have to start being fully compliant with FACTA and all the rules. And they had a special session of the Assembly last week and voted in all of the regulations requested by the anti-money laundering people. So Belize is not a good place to go if you're trying to not pay Uncle Sam his due or launder money for any type of criminal adventure. If you're just some lawyer, some doctor, some high school principal, some entrepreneur who's made some money because one of your ideas, or you just worked hard and got some money together, it is a great place to protect it. But it's not a good place for bad people to come, and that is a message they're trying to get out there. It was established as a financial center after all the money laundering, all the crooks were putting their money in the Caymans. The Caymans was built on drug money. Everybody knows that. Same with Bermuda and Bahamas in large parts. That money hasn't come to Belize. They're not going to get that money, and they're just trying to be clean. Nevis is cleaning up their act. Everybody's cleaning up their act, or they're going to be excluded. And that's what's happening. Whether you like it or not, Uncle Sam knows everything you do, period. There's no such thing as a secret bank account anywhere.
Great. I just want to share the results of this, the current poll that we have. We have almost as many first-time attendees on this webinar as we have people that have been here 2 or more times. That's pretty exciting. So,
yay!
Yay.
I like that.
Welcome to all of you first-timers, and thank you to those of you who've been here multiple times. So I'm gonna put up one last question here, or one last poll as I ask Rob the last question, and that question is very simple. What are the best countries to create a foreign asset protection plan in, and what is the best country, safest country to keep your money in? In other words, open a bank account.
Okay. I love Switzerland for bank accounts, even though they will tax you on the money. You get a tax credit. I really enjoy Holland because nobody speaks Dutch, and the ABN AMRO Bank there is one of the strongest banks in the world. I love Singapore. They don't cooperate with anybody even though they're transparent. I love Belize. You can't hardly seize money in Belize. They don't have computer records like you do in Bank of America. Somebody comes here and wants to get your money, they have weeks and weeks of work, and it's not a comfortable place to sit here for weeks and weeks working. I love that. So the best place for trusts are any country in the world that recognizes trusts, because no country in the world recognizes U.S. judgments. If you need rough and tough laws, Belize and the Cooks are by far the best sets of laws. I like Belize much better because Belize has 47 or 50 trust companies and some competition. The Cooks, last time I checked, had 7. My book was written about the Cooks. I love their laws. I love Belize laws. Belize is in the same time zone. They speak English just like they do in the Cooks. The difference is I don't have to get up at 2 in the morning to talk to somebody. So I'm a Belizean supporter mostly. I love St. Lucia because it's an easy place for me to do business. And almost any good bank anywhere in the world is a fine place. Don't put your eggs in one business. Abby, we can hear you. Okay, that's my answer.
All right, thank you. So, Rob, let's close it. If anybody has questions that they need to get answered, where should they send them? Support at AssetProtectionTraining.com?
That's the perfect place to send it. Support at AssetProtectionTraining.com.
Okay, I'm going to type that into the chat box so everyone can see it. And as we close this, I just want to say thank you to everyone who attended. It's a real privilege to do this for you. We hope that you learned something new, got some questions answered, and we're going to take all of the questions that have been submitted, and perhaps Rob will put together just a Q&A webinar in the future where we can address some of these.
I'd love to
also,
do that.
Yeah, I just heard that the webinar from last month, the video finally got worked out. So for those of you who were interested in that, we will have a link to view that webinar going out soon. And we will not have that same issue with this webinar. There will be a replay available within a couple days. So with that, I would like to say thank you. Rob, go ahead and close us out. And I'll leave the poll up for just another few minutes for any of you who would like to continue to answer that question. And then we'll be done. So thank you very much, everyone.
Okay, I'm going to close with something important. I know that a lot of you have questions, and I know domestic asset protection is very, very exciting because, first of all, it doesn't have the fear, that funny feeling of going away from the U.S. And that's really a funny feeling. I understand that. And it also feels good because it appears to be blessed by the various states like Delaware and Nevada. I can tell you, they're not effective. If you have a domestic asset protection plan in place and you're headed into trouble, you need to move that plan, and you need to move it before the problems arise. And I'm not kidding, and this isn't just some stupid sales pitch. It's something you really need to do, and it's something that I would not wait. Domestic asset protection is, in my mind, a fraud. It does not work. As I said, there has never been a case where a plan was challenged and it held up, period. And that is the truth no matter what anybody says. And also, I want you guys to send us emails, support at AssetProtectionTraining.com, more questions and more topics. We're going to do we've been doing one webinar a month. We're going to continue to do it, but give me the things you want to hear about, and I'll make sure that you get your questions answered and your topics handled. And Tony and everybody, thank you very much. Thank you very much for helping to do this. And that was me clapping.